Thank you all. Good afternoon, everybody. Joe Goff. I appreciate the opportunity to be with you today. This is a little bit different the way that we're doing this today, but it's a great setup that they've created here at the Library Commission for this. Everybody can see and hear me okay, and we're good to go then? Awesome. So today, what we're going to be talking about, and you can all see also the PowerPoint too, right? Okay. No, some of y'all? Yes, everybody can see it. Okay, so our title of the PowerPoint is, of course, personnel policies, and that's what we're going to be talking about today. We're going to be talking about personnel policies, your personnel handbook. We're going to be talking about a couple of very specific issues, but y'all, I really want to elicit some feedback from you today, okay? And ask you some questions and get some information from you as we go forward with this. And the project is this, like Jennifer said in the email to you about this particular session, is that the Library Commission, they intend to make some updates to the Public Library Policy Development Guide. Those of you that have been around for a while, you remember when this was first done by the Library Commission back in 2010. It was updated in 2021. I'm sorry, in 2021 it was updated. And we're looking at doing some additional revisions to it also based upon the need for some updates in the policy or in the policies in the development guide. Of course, the intent of that development guide is to give you some template policies to use concerning personnel issues and to address those. And of course, there's plenty of room there. There's plenty of room there for you to make those policies specific to your library system, to your library, to the personnel there, to your organizational chart, etc. So that was the goal of the policy development guide, and we want to make some revisions to it now. And in anticipation of this, Jennifer, she's received a number of your personnel policies. I've looked through the personnel policies, went through as many of them as I could, and sorry, I'm seeing some chats here. Okay. I've gone through as many of these as I can, touched on specifically looking at your policy's disciplinary processes and procedures. See, I just lost lost everybody here. There we go. Y'all are back. Okay. So I looked specifically at disciplinary processes and procedures in a number of the policies that were sent in to Jennifer, and looked also at your policies concerning workplace harassment reporting, employee complaints, grievance processes. We're going to talk about that today, and I really want to elicit some information from you as we talk about that. The 2010 and the 2021 policy development guides, they were both silent on grievances or grievance processes. We're going to talk about that today, though, because many of you have in your policies, you do have a grievance process for employees to advance issues all the way up to your board of trustees, and we're going to discuss that. I'm going to tell you some different things that jumped out at me in looking at those policies. Again, as y'all know, we don't have an attorney-client relationship here today, but I'm going to be talking about, based upon my experience in the past, my interpretation of these statutes, and best practices also. But I want to stress to you, if you got your own attorney, that's who you're going to rely upon for these issues that we talk about today. But I'm going to raise some issues that I think are important for us to talk about. Again, the policy development guide that the Library Commission is going to be working on some updates to here in the near future. I think that it's important, though, that y'all need to look at your policy guides currently and make some, and some of you need to make some revisions, or at least need to look at making some immediate revisions. And I'm going to shoot real straight about that in just a little bit, okay? So but we're going to do two things, though. We're going to talk about disciplinary issues. We're going to talk about there we go. We're going to talk about disciplinary process and addressing employee concerns in your policy. When we say employee concerns, y'all, that can mean a number of different things. That could mean that your employee has a concern about a dispute with a coworker. Maybe they have an actual workplace harassment complaint. We're going to talk about the differences between the two. We're going to talk about from employee concern standpoint, a personnel decision that maybe an employee has a concern about or a complaint about. Maybe a particular assignment, a promotion decision that you made, a salary compensation decision, maybe an assignment, maybe a transfer, whatever it might be, some personnel decision that gives your employees a concern. Or maybe the concern is again that they're asking for, they need an accommodation and they're asking for an accommodation under federal law. So we're going to talk about that. We're going to again also talk about the responsibilities of the director and the board of trustees as it relates to your policy guide. And again, any questions that y'all have, shout them out, okay? If you put them in the chat, we'll be monitoring the chat, or just raise your hand, interrupt me, get my attention as we go, okay? Let's go ahead and dive into it now. When we talk about your responsibilities, of course, and we've discussed this before, but the director's responsibilities for your library system, they're in 39317, subsection 2. Y'all are all aware of this. Employment of staff with the approval of your board of trustees, of course. Staff duties, describing staff duties, assigning staff duties, prescription of staff duties for the people that work for you there in the library. Removal of staff, and I've underlined those two words right there, for cause. Removal of staff for cause, okay? When we talk about for cause, that's an important phrase that I'm going to discuss quite a bit here initially. This is the phrase, y'all. This is the phrase in 39317.2 that gives your staff certain job protections in the workplace, okay? 39317.2, when it uses that phrase, that a library director's responsibilities include removal of staff for cause, that is what separates your staff from being a will and pleasure employee, okay? And in looking at a number of y'all's policies, there are references to your staff being will and pleasure. And I'm going to talk more about that, but those are some things that I think require some immediate attention on y'all's part that we'll discuss more in a little bit. But that section, removal of staff for cause, that's a section that gives your employees, again, their job protections. It's the legislature in 25-9-127. They did the same thing for state employees, for state service employees, employees who have served their initial 1-year probationary term. They earn state service status. And the legislature in that statute, they stated in 25-9-127 that those employees are entitled to due process of law before they can be terminated, demoted, suspended without pay, formal disciplinary action that impacts their employment status or compensation. And they also said this, they said that that disciplinary action can only be for good cause. They use the phrase good cause. And when they did that, when the legislature did that, it created what's called a property right interest in that the employee has in their job, meaning that for their job to be taken away from them or adversely affected, then they're first entitled to due process, which means notice and a meaningful opportunity to respond to the allegations against them. When we say notice, I mean giving them notice of what exactly it is that they did that warranted that disciplinary action or the proposed disciplinary action, and that they have the right then to appeal that decision. They have the right to give a response to that potential disciplinary action before that disciplinary action is issued. Well, the process is a little bit different for removal of library employees, as you know. That's the process that the legislature established through the Mississippi State Personnel Board for the 25,000 state employees who fall under the SPB. The process is different for your library employees, but the legislature, they established exactly what that process is. More on that in a moment. Of course, you're responsible for the preparation of the budgets. You are responsible also under 39317.2 for financial and statistical management of the library. You are reporting to your board of trustees, and then any other acts, this is very broad, but other acts necessary for the orderly and efficient administration of the library system. Now that's an important phrase also, okay? Other acts necessary for the orderly and efficient administration of the library system. We're going to talk about that in the context in a little bit about employee concerns. Having policies and procedures to address when an employee has a concern, such as some type of a dispute with a coworker, or maybe the employee has a complaint about workplace harassment. Maybe they have a complaint over not getting a promotion, of their salary being less, et cetera. So we can have processes and procedures to address those issues also. And that falls under this category right here, other acts necessary for an orderly and efficient administration of the library system. Your director responsibilities, bottom line, you shall administer and establish procedures, as you know, according to policies established by your administrative board of trustees. I know that many of you have worked with many different boards, many different trustees in your career. I'm sure and I've represented a lot of boards. I've represented a lot of commissions. And the boards and commissions that I've represented, the members of those boards and commissions, they often fall into the group of those that are very involved and want to be very involved and want to know exactly what's going on and kind of get in the weeds and in a lot of detail. And I'm not being critical of that, but often, as you know, some of your trustees, they fall in that category, and others, they rely upon you. They've selected you, they've hired you, you work for them. They've hired you to take care of these issues and to administer policies and procedures for the orderly and efficient administration of the library. They rely upon you to do that. So I know that folks can fall into different categories, but you're to establish these procedures according to policies that are established by your board of trustees. And they're often going to rely on you, of course, for the preparation of those to be presented to them. Your board of trustees' responsibilities: adopt bylaws, rules, and regulations for your own board of trustees' guidance and for the government of the library as they deem expedient. Employ a library system director, that's you, to prescribe your duties, fix your compensation, remove that library director if warranted for cause. 39.317.1, what else? Your board of trustees' responsibilities: employ upon the recommendation of the library system director such other staff as may be necessary and fix their compensation. Well, how about this last one then? Do all other acts necessary for the orderly and efficient management and control of the library system. So the director, you've got the responsibilities for the orderly and efficient administration of the library system, and your board of trustees has that same responsibility also, okay? Y'all, like we said earlier, in the statute 39.317 that we looked at just a little while ago, and we're going to look at it in more detail too, it has the process for termination for library staff or library employees. I talked earlier about that with the Mississippi State Personnel Board for the 25,000 state employees, for the state agencies out there. There's a process that is established for due process, disciplinary action only for good cause. And then all of that is then fleshed out in the Mississippi State Employee Handbook for all state agencies and for all state employees. A little bit different, but the same thing for our library employees. 39.317 states that in the event that a determination is made by the library system director to remove a staff member for cause, written notice of such decision shall be given to such staff member. So again, that phrase "for cause" is really important, okay? That's what separates your employees from being will and pleasure employees. It provides, like I said, a property right in their job. The statute states what that required process is. So let's talk about this in the context of probationary terms and probationary periods. The state of Mississippi, again, I hate to keep referencing the State Personnel Board, but I think it's important to look at that for guidance for the personnel system for state employees. And the State Personnel Board's system for disciplinary action, it mandates that, again, that due process, that written notice of the allegations against somebody and the opportunity to respond before that disciplinary action takes place. But that is not the case for a probationary employee. Probationary state employees who are within that first year of employment, they're trying to earn through successful performance of their job and following all the rules and regulations. They're trying to achieve and earn what's called state service status. That occurs at the 1 year mark for a state employee. At the 1 year mark, that state employee then has state service protections, and they're no longer will and pleasure. Now, a probationary state employee, they still have the job protections from discrimination, the federal law protections. So when I say that someone is will and pleasure, When I say that someone has will and pleasure, that means that they do not have to be provided with due process before they're fired, demoted, suspended without pay. They're not entitled to due process first. Now, there still needs to be, of course, some underlying cause, some underlying reason. We wouldn't fire a probationary employee for no reason at all. There would be some underlying documented reason, but they're not entitled to that process first. That's the difference. That's the difference between will and pleasure and non-state service. So in looking at the policies, that a number of the policies, not all of them, but looking at a number of the policies that were sent into Jennifer Yellen and glancing at what I saw as far as disciplinary sections, and I'm not going to identify that any of these different systems or libraries by name, but I want to tell you some things that I saw, and this is important for you to look at your policies either as we talk about this, what your disciplinary policy states or process, or when we finish, okay? I'll give you some examples, and I'm quoting here. One policy from a library, probationary employees must serve 12 months in their position, and they may be dismissed at any time during their probationary period, while a, quote, permanent staff member may be dismissed only for cause. Y'all see the issue there? Okay. Um, Again, that probationary period, there's no difference in that statute, y'all, for the in 39.317. As far as process-wise for termination of a probationary employee, a new employee versus a long-term employee, or someone who is, in this, they refer to them as a permanent staff member. Process-wise for removal of that staff member, it's not, it's the same process. Okay. Let me tell you another one. Again, I'm not using names here, but this is from another library in your current policy. During the probationary year, the director may dismiss an employee for any reason not prohibited by law. Again, it's for cause. It should be for cause. Another one, in the first 6 months, employees are on probation, and the employer, quote, may terminate the employee without prejudice. I think they were intending there, I'm not sure, but I think that it was intended to mean with or without cause, but I'm not sure. But bottom line, again, it's to be for cause. Um, Another one, the director has the authority to remove staff, quote, at will in accordance with Mississippi's at-will employment law. That policy actually reads as if all employees, not just employees who are in a probationary period, but that all employees are will and pleasure at will employees, and they're not again. So I wanted to bring this to y'all's attention for there to for that to for you to look at that. It needs to be on your radar. David Scott, to everyone, is there a difference between full-time and part-time employees? I assume not. I would go through the same process with the part-time employee. It's a good question. Okay, the statute doesn't make a difference or it doesn't make a distinction between full-time and part-time as far as the process is concerned. Now, I'm going to talk also, though, I don't want you to think, man, Goff got on here and he said that we can't fire our probationary employees and we've got a poor performing new employee we can't terminate. Not saying that at all. Not at all. I'm just saying that they're still entitled to that same process. I'm going to talk about probationary employees in a moment, or that probationary term. One other thing, that particular library systems policy, it also stated that, quote, terminated employees can appeal the decision using the employee grievance procedure. No, there's a statute. The statute states what the process is for an employee that wants their termination to be reviewed by the Board of Trustees. We'll look at that process in just a moment. But again, I want to raise that one to your attention. One more. And this is a current policy from one of the library systems right now. The policy states that employees must sign, when they're hired, a notice that acknowledges, quote, your employment is at will and you may be terminated at any time with or without cause. This appears to be, y'all, this statement in the policy that employees are required to sign, it appears to be for all employees, again, not just probationary, but for all. It wouldn't be appropriate even for a, quote, probationary employee, okay? But certainly not for your other employees also, okay? Questions about that so far? Okay. The termination process. And it's mandated by statute, the termination process. And that termination process, of course, written notice of the reasons for such action, together with a summary of the factual basis for the decision. Okay. And we've looked at that before. We've done that before in training. Remember in the training we did last year, and I presented to you a sample termination notice that it references past progressive disciplinary and corrective action that we went through with an employee. It references exactly what the performance, conduct, behavior issue is with the employee. It references um, past warnings, attempts to correct through informal, corrective, or less formal disciplinary action. It references all the training notices given to the employee. It doesn't have to be a book, but it needs to be a good, sufficient summary of the factual basis, the background for that decision. Okay. And they have to be notified, of course, that they have an opportunity if they choose to for a hearing before the Board of Trustees at which to present matters relevant to the reasons given for the decision, including any reasons alleged by the employee to be the reason for the decision. Okay. And the written notice must be presented to the employee, of course, at least 5 days. Okay. At least 5 days before the hearing with the Board of Trustees. Let me go back to this for just a moment because I want to mention this also. We're going to talk about grievance processes in a moment, but one of the things that I saw in a number of the policies also, it stated that a terminated employee may use the library systems. Let's see, the question here is 5 calendar days. Yes, 5 calendar days. That the statute does not say working, but it's got to be at least 5 days. If you want to make it 5 working days, absolutely. That's no problem at all. Okay. Um, so y'all, let me go back to I lost my train of thought. I'm sorry. The many of you in the policies that I saw, you incorporated an appeal to the board of a termination decision. It was incorporated into what you have as a grievance process. Okay. Standard grievance procedures, and with the state of Mississippi, it's a two-step grievance process. It's very limited. What are issues that are grievable? I'm going to talk more about that in just a moment. Um, but the grievance process, it begins with the state system, it begins with being filed with the Human Resources Director at that agency and ends with a hearing. I say hearing, an informal meeting with that agency's appointing authority, the executive director of that agency. And the decision that's made by the final appointing authority, agency director there in that circumstance, can be appealed to what's a separate third party created by the legislature, the Mississippi Employee Appeals Board. Okay. Many of you have grievance processes that allow for, and I'm going to talk more about them in detail, but they allow for employees to appeal to your board going through a 3-step or 4-step grievance process, appeal disciplinary action to your board of trustees, whether it's a written reprimand, a suspension without pay, a demotion, something along those lines. It allows for that to be grieved to your board of trustees. More on that in a moment, but many of you include in that termination, that an employee can file a grievance over their termination. And y'all, that's not correct. Okay. The process is in the statute. And we just looked at it on the previous or on the slide that's before you right now. Got to give them the written notice that states the reasons why. They've got to be given notice that they have an opportunity to challenge the decision, to present reasons to your board of trustees for what the decision was made actually based upon. They're arguing, or they might say that it was really a pretext for another reason for the decision. And they're able to challenge that at your board of trustees as long as they comply with these processes. And the hearings to be fair and impartial, they may be represented by their own legal counsel, etc. This is the process for removal for a terminated employee. It's not that they file a grievance. and go through your internal grievance process. That should be for something completely different. Questions about this, y'all? Okay. These are just some highlights on different things that jumped out at me. Again, I don't want you to go back and say, hey, we got to go off, so we got to change a bunch of things in our policies. But I do want to point out some things to you that I think it's important that you do go back and look at your disciplinary sections, your sections in your policy that reference probationary status for employees or that reference employment at will policies or for employees, that you go back and look at that and make sure that it's consistent with what the statute actually states. Okay. And this is something that we'll be addressing in with the Library Commission's update to the policy development guide. We're going to ensure that this is addressed for all of y'all too. Okay. No questions on that. Okay. Let's keep going. Let's keep going. Let me ask this. When we talk about this termination process, again, the hearing before your board of trustees, it must be fair and impartial. Okay. This is where I want to, okay, question. Does the employee have a time limit on when they can request the hearing? Great question. Yes. We can put that time, yes, the employee can be provided with a time frame for them that they have to make the request. Okay. Needs to be a reasonable time frame for them to make that request. Um, if they make that request, we've got to give them a certain period of time. Again, before that, we give them notice of when the hearing is going to take place. Let a certain reasonable period of time pass then before that hearing actually takes place. But yeah, we can put a deadline on them. Again, a reasonable deadline for them to make the request to the Board of Trustees. Okay. And again, I'd err on the side of caution of that being a reasonable period of time. Uh, the written notice. Okay. So talking about the probationary period, what is a probationary period? What's the purpose of it? I've talked about probationary periods before for your new employees who've just been hired. Uh, and what's the purpose of a probationary period of time? And, I've got here on the slide, to me, it's a period of time to train, communicate, and evaluate your staff, okay? Giving your employee every opportunity for success during that period of time. Okay, during that period of time, and y'all, if I'm missing any in the chat, okay, please let me know. Okay, any questions or comments in the chat. Um, Giving them every opportunity for success during a probationary term, y'all, we have a heightened level of evaluation of that employee's job performance, a heightened level to me of meeting with that employee. Again, they're new. They want to know how they're doing. They want to be coached up. Okay. They want to be told what they're doing. Do they need to improve? Are they doing okay? They want to have their questions answered. You need to be accessible to them during that probationary year. Make sure that their supervisor is accessible. Make sure that during that probationary term that their supervisor is meeting with them, that their supervisor is training them and giving them, again, every opportunity for success. But you are closely evaluating that employee as far as their job performance, okay? With the state personnel board system, during that it's a 12-month period, during that probationary period of time, that employee truly is will and pleasure, meaning that they can be fired just by being handed a termination notice. Okay. I don't like the phrase with or without cause. We're always going to have some underlying reason. We know that. There's going to be a documented underlying reason, but that probationary state employee, they're not state service status. They can be fired without being provided first due process of law. And it does not have to constitute good cause, but there's got to be some underlying reason in case there's a discrimination complaint. For your probationary employee, your new employee, I saw some of you had 12-month probationary terms. I saw some policies that had 6-month probationary terms. I saw a number of policies that allowed for probationary terms to be extended for employees. And again, during that probationary term, this is the intent. The employee knows. Look, the employee is aware that I'm being closely monitored. My job performance is being closely monitored, And I'm being evaluated on whether or not I'm a good fit for this position by my employer. Okay. But the removal process is the same as if I'd worked there for 5 years. Okay. The removal process is going to be the same. It's still going to require that notice. It's going to require the statement about the underlying reasons for it, warnings, whatever it might be. Now, with that probationary employee, again, that's the same process. They're still being terminated for cause, and we can reference in that termination notice that you are a probationary employee, you're within your probationary term, and as such, your job performance is to be closely evaluated, blah, blah, blah. You could make statements like that. We'll give you some sample language, et cetera, for that too down the road if necessary. But we want to state what the probation, we're not firing the probationary employee just because we want to. There's a reason why. There's a reason why, but we did everything to make it work. It's hard to find people. It's hard to hire people, and you get them hired, you get them on with you, you start training them and working on them. We want it to work. We want it to be successful. But if it doesn't, you're going to state what it is that that new probationary employee that they failed to do, performance wise, something they did conduct wise, is there an issue behavior wise, whatever it might be. We're going to address that issue, okay, in that notice. Questions about that? Okay, before we move on. Well, let's now talk about addressing employee concerns. And when we talk about addressing employee concerns, big topic. I'm referencing these four different type of concerns that employees raise in the workplace. This may be a new employee, this may be a long-term employee, but policies to address employee concerns. And y'all, in looking at the policies that Jennifer had received, and she hadn't received all of y'all's, but just some. And in looking at those, everybody's got a little bit different way of how they address or handle employee concerns. Um, I'm going to talk about grievance processes in just a moment. But in handling employee concerns, I saw some that were very informal, that encouraged employees to try and work it out among themselves, and some where things it was not far from a workplace harassment type complaint. Okay, and some policies that I saw where it conflated workplace harassment complaints with coworker disputes and how that employees should try and work those out among themselves first to begin with. More on that in a moment, but that's something I'm not super comfortable about with, let's say that an employee, they come to you about a dispute with a coworker. We've got to be able to recognize, look at that next line down in the PowerPoint, when the complaint actually concerns alleged workplace discriminatory harassment. Okay. And what's the appropriate way to address that? Workplace discriminatory harassment that's not a grievance. That's not something that should be a part of a three-step grievance procedure where the grievance is filed with the supervisor and the supervisor then has a certain period of time to respond uh, to the allegations. That's not what we're after. Okay. That's not what we're after in this. We need to have the workplace harassment policy and the response requirements. We need to have that separate from a grievance process. More on that in a moment. Personnel decisions. Employees that are concerned about a decision that you made, director, concerning their salary. Maybe other staff received pay increases, but they did not. Promotion decisions. They applied for a promotion, a competitive process, and they didn't receive it, maybe. A particular job assignment that an employee is upset about, that they do not like, that they don't care for. Scheduling. An employee has been denied a particular schedule that they've asked for, or they've been directed to work after hours and they don't feel like it was fair. They don't think you were fair about how you did that. How about this? Disciplinary action less than termination. And just about all of y'all's, or all of the policies that I looked at that had grievance procedures, they allowed for employees to file a grievance concerning disciplinary action that they received less than termination, meaning a formal written reprimand, a suspension without pay, maybe a demotion to a lower level paid position. All of that's less than termination, and all of those three disciplinary actions, They do not trigger that statutory process in 39.317 like removal does. Okay. Your library director, you've got a great deal of authority concerning that disciplinary action for employees less than termination. Your policy and procedures manual, many of them go into great detail, though, about the different type of offenses that can result in disciplinary action and what that should be, the number of disciplinary actions that somebody should receive before they are fired, suspended without pay, etc. Um, that's a personnel decision when you do that. And if an employee has a concern that I shouldn't have received that formal written reprimand, or I shouldn't receive that 2-day suspension without pay, a number of you have processes where they're allowed to then grieve that. So if an employee has been suspended without pay, that was a decision that was made by you, the library director. You're not going to delegate the authority. I don't think that you really even could to delegate to the authority to a supervisor to suspend an employee without pay. That's a big deal. Couple of 3-day suspension without pay. That's a decision that's going to be made by you. Well, to require that employee then to go through a grievance process to challenge that, where they first filed the grievance with their immediate supervisor, when this was a decision that was made by you, the higher level library director, well, what's this supervisor going to say about your decision to suspend the employee or your decision for that employee to be issued a written reprimand? You see, it's not just from a practical standpoint, it doesn't work. Um, the last one that we're going to talk about also, accommodations. We've done a lot of training and talked about different accommodation issues. They fall under the Americans with Disabilities Act, these accommodation request issues and considerations. The Americans with Disabilities Act, um, the new Pregnant Workers Fairness Act that we've talked at length about in the last training. We did a great deal of training on the new Pregnant Workers Fairness Act. That law also, it requires that an employer must provide an accommodation to a pregnant worker who has limitations in the workplace due to their pregnancy or related to the fact that they're pregnant. We've talked at length about what those different accommodations might look like. And just like with the Americans with Disabilities Act, just like with ADA, the standard for whether or not the employer has to provide the accommodation, it's a reasonable accommodation requirement. The employer does not have to provide it if it would cause the employer an undue hardship. Okay. And the third area, religion. Religion. That's under Title VII of the Civil Rights Act. It was passed in 1964. It protects us from religious discrimination. In 1972, the law was amended to require that employers had to provide reasonable accommodations for folks who have who are in need of a religious accommodation, of a particular religious belief that conflicts with a job duty or requirement or scheduling requirement, whatever it might be, in their religious faith. It conflicts with that. In that circumstance, the employer must also provide a reasonable accommodation unless it causes the employer an undue hardship. 2 years ago, and we've trained about this also or talked about this, the Supreme Court, they revised the standard for what is an undue hardship under Title VII's religious accommodation requirements. They revised that a couple of years ago. Prior to 2023, that standard was whatever caused just a minimal amount of disruption to the employer's operations or a minimal amount as far as cost or whatever it might be can be considered an undue hardship. Frankly, the undue hardship standard prior to this change in the law in 2023, it was a lower standard for an employer to claim undue hardship for religious accommodations versus ADA. That all changed 2 years ago. And in looking at a number of the policies, there needs to be some updates made as far as religious accommodation and undue hardship from what I saw, and that'll be addressed also in the new Library Commission Development Guide, Policy Development Guide. But I just wanted to alert you that when we talk about accommodations, the law changes all the time. And I saw in a number of your policies that they went into a lot of detail concerning what the employer would consider as far as accommodation, what constitutes undue hardship, etc. And the law changes all the time, y'all. The law changes all the time. So And when we talk about accommodations, this is something that I've seen with a number of different state agencies and state personnel board also, where I don't want to say less is more, but as far as their policy concerning accommodation obligations versus undue hardship, they're rather broad. Okay, they're rather broad rather than being so much in providing so much detail in the weeds about the accommodation and interactive process, like I saw in some of the different policies. So what am I talking about? Let me skip forward to this slide right here. Okay, let's talk about accommodations. This is, and in the policy development guide, we'll provide this also. Okay. There's a lot of words right here on one slide. I get it. Tiny words too. Okay. Um, but this is an example of what a good policy can look like concerning accommodations. What do we, and notice this isn't a grievance process. This doesn't require employees to file a grievance and go through a first step, second step, third step. If they disagree with the proposed or with the finding of the library director, they can appeal that using the grievance process on whether or not the accommodation was an undue hardship to your board of trustees. We're not talking about this being a grievance process. This is different. And what we say here is that the Americans with Disabilities Act, it requires that employers provide a reasonable accommodation to qualified individuals who are employees or applicants for employment unless meeting this obligation would cause undue hardship to the agency or to the employer. You can substitute whatever right there. Okay. You'd substitute your library system's name right there. Title VII of the Civil Rights Act of 1964, it prohibits employment discrimination based on religion, and employers are required to accommodate an employer applicant's sincerely held religious belief or practice unless the accommodation would impose an undue hardship on the employer. Again, you substitute your library system's name there. The Pregnant Workers Fairness Act, the Pregnant Workers Fairness Act, it requires that employers offer a reasonable accommodation for a qualified employee's known limitations related to pregnancy, childbirth, or related medical conditions, unless the accommodation would cause undue hardship to the agency. Remember in past training when we talked about the Pregnant Workers Fairness Act, some example accommodations allowing the employee to sit down, allowing the employee to have snacks, to hydrate during the day, to have maybe longer break periods or additional break periods, etc. Unpaid leave, period of unpaid leave for someone that does not qualify for leave under the Family Medical Leave Act, but they are in the need for unpaid leave due to their pregnancy, childbirth, etc. Okay. Um, let's look at the next step or the next part of the policy. An employer applicant for employment, they may submit requests for accommodations pursuant to these federal laws, and management will promptly engage in an interactive process with the employer applicant, and requests for accommodations shall be submitted to blank. Y'all, I saw in some of the policies that it directed that employees that were asking for an accommodation under the ADA, Americans with Disabilities Act, that they were to make the request initially with their first level supervisor. You know, and I know that your size, the size of your staff, that it certainly varies, and it varies the level of HR support that many of you have also. This is something, if an employee feels like they're owed an accommodation or they're entitled to an accommodation under the Americans with Disabilities Act, to me, that's such a serious thing. I would want for that request to be made directly to you, the library director. Now you've got supervisors and they're who work for you. Okay. But this is again, I'm asking for some input here, y'all. What do you feel about, what are your thoughts about requests for accommodations, whether it's for pregnancy, ADA, or religion, being made directly to you as the director rather than through a supervisor? Thoughts? Yeah? Yes? No? Maybe? Okay. Well, my thought would be that it should go to you. Okay. Okay. Thank you, Sydney. I feel like that's something that should go to you. Look, that's not something that we want to entrust to me. This is just Joe Goff's opinion. Okay. Y'all may want to do something else. Okay. And that's fine. But to me, that's something we don't want to entrust to a lower level supervisor Maybe they don't promptly, immediately bring it to your attention. Maybe they try and handle it on their own, or they might make a statement that they shouldn't have made, or whatever it might be. That's a big deal, okay? And for somebody to make that request, and our response is a big deal also. So we would just fill in the policy. And what this is an example of what your accommodation policy can look like. It could be incorporated all into just one policy for all three different types of the federal laws that require accommodations versus undue hardship. You'll see this hopefully later in the library guide. What else? Management, we're now describing the interactive process. Y'all, in our last training, we talked about what that interactive process is, what it mandates for employers. And this is it. This is straight from the EEOC. And we can have this in policy, and it tells our employees what we will do and what they should expect. Management will promptly engage in the interactive process with an applicant or employee with a known religious practice or belief that conflicts with a job requirement. The parties will communicate with each other about the requested accommodation and the alleged conflict between the job requirement, the employer applicant's religious belief or practice. Y'all, as a lawyer, represent a lot of state agencies and HR issues. I had a lot of these meetings, and that is exactly what that interactive process requires, that we document that we're prompt. Now, you're going to be meeting with that employee supervisor, certainly, as there's a determination made on can we provide this accommodation or would it be an undue hardship? And this is what we say here at the conclusion. In each circumstance, management will assess the accommodation request in good faith and in compliance with all requirements of the ADA, Title VII of the Civil Rights Act, and the Workers' Fairness Act. Accommodations agreed to by management will be timely implemented, and a determination of undue hardship will be promptly communicated to the employer applicant. A request for accommodation pursuant to these federal laws is considered protected activity, and retaliation against an employer applicant for making such a request is strictly prohibited. There you go. And that would be that's good, strong accommodation policy. It states exactly what federal laws are applicable, where the employees are to go to request the accommodation. There will not be any retaliation, and it states exactly what you're going to do on your end once that complaint, or not the complaint, but the request has been made. Okay. Let's talk about, as far as addressing employee concerns also, the coworker dispute in policy. How do we address in policy coworker disputes versus a complaint of discriminatory harassment? Okay. Maybe I've got a coworker that is on my nerves, and I go and complain to you about that coworker, and that they are just on my nerves, and they're not professional, and they bother me, and they keep me from being able to really focus on my job. Well, that's going to warrant more questions from you. Well, what is it that makes that you find them to be so unprofessional about, and that they interrupt you and keep you from being able to focus on your work? Well, that response, once you ask that question, it may be, well, they're constantly telling me dirty jokes, or they're constantly saying things that are out of line, that are off color, that they're constantly making critical statements of me concerning my religious belief, or maybe lack of any religious belief. They're constantly making comments or statements to me, or sending me emails that are of jokes, or teasing, or picking, or offensive, flat out just offensive, concerning my race, religion, sex, national origin, how old I am, my age, a disability, my need for an accommodation, or making comments to me about past protected activity I've engaged in, or making a complaint of discrimination. When you dig in, y'all, that complaint of that coworker dispute, it may be a whole lot more. It may be a complaint of discriminatory harassment. And that's why it's just so important that in our grievance processes and our grievance procedures, that we make it super clear that somebody that wants to make a complaint of workplace discriminatory harassment, that is not a complaint, or that is not something that requires them to just go through a grievance process. And a number of your grievance processes that I saw, very, very broad, y'all, very broad on what's a grievable issue. And some of the policies, and I say y'all's, I'm sorry, then the your current policies. Um, one that I'm reading right now, it stated that it's a grievable issue. Okay, it's a grievable issue and could trigger the grievance process, quote, any feeling of dissatisfaction or injustice in connection with one's employment situation. Wow, that's a grievable issue. And it triggers the grievance process. Any feeling of dissatisfaction or injustice in connection with one's employment situation. Um, that could be about anything. And if it triggers your grievance process, where does your grievance process end? It ends at your board of trustees, right? So does this kind of open the door for just about any issue to ultimately land at your board of trustees? You know, your board of trustees, that's what they've hired you for, is to handle those type of things. And this is a balance, you know, this is a balance. Your board of trustees, they're responsible for the orderly and efficient management and control of the library system versus the statute. It only requires from that the removal process can be appealed to the board by an employee. If anything can be grieved or appealed to the board, anything, then you know that may not be very efficient. That could be very difficult for you as the director, I would think. And also, you know, your board hired you to handle a lot of these issues, right? So when we talk about a grievance process, and more about that in a moment, but it's very important that we ensure that employees don't confuse grievance process with making a complaint of workplace discriminatory harassment. Your harassment policy, it should direct employees to report workplace harassment immediately and offer options for notifying management. Okay. Um, Instructions on reporting harassment, discriminatory harassment, again, this needs to be separate from any kind of a grievance process. I saw some policies that combine these two where it stated that it's a grievable issue if you're facing discriminatory harassment. Um, if I'm being, and the grievance process had a deadline that if you didn't file a grievance, it was then waived. If I'm being sexually harassed and I fail to use a grievance policy that I have to file within 7 working days or whatever it might be, otherwise I've waived it. Well, maybe it took me 7 working days to get the courage up to make a complaint about this. Okay. Or maybe 10 working days or whatever it might be. I haven't waived anything by not using a grievance process, and we want to be careful that we don't give that impression in our policies. So the harassment policy, it needs to state directly who folks should report to workplace harassment and offer options then, okay? For me, and now this is another time where I'm asking of y'all. Um, it's not part of a grievance process, but if you've got one of your employees, yeah, they may have a supervisor, okay? They may have a supervisor that reports to them, that reports to you, or several levels below you. Where should that employee, if they are being sexually harassed, racially harassed, harassed about their ethnicity, whatever it might be, personally, it's just another area where that, to me, that's a complaint that should be made directly to you as the library director. I mean, that's just my opinion, y'all. Okay. What are your thoughts on that? What are your thoughts on that, director? Okay. Anybody necessarily disagree with that? And it's fine if you do. It's perfectly fine. I know that many of y'all have got some pretty large staffs. Okay. Some of y'all are smaller staff than others. Some of y'all have got quite large ones. Okay. But to me, that's something that employees should know they can go directly to you about as the director. Again, we want to give options. Okay. Let's say that the complaint is alleges discriminatory harassment by the director. Then obviously the employee shouldn't be directed that they have to go through the director to make that complaint. You know, that's a circumstance where I think an employee could make or should we've got to give them some opportunity to be able to make management aware so we can address the situation. But in that circumstance, reporting that directly to the chair of your board of trustees. Okay. I think that that would be appropriate. Okay. I think that would be appropriate. Also, HR. I know that a number of you have limited support from HR or limited support as far as HR is concerned. I'm not being critical of your county or HR departments or et cetera, but I'm not. But some of y'all have limited resources there and are access to support. Some of you have more than others. And if you've got a human resources personnel officer affiliated with your library system, allowing for that employee to make the complaint directly there. That's an opportunity also, okay, for the complaint to be made directly there to your HR designee, and then they would notify you, of course, as the library director, and we would initiate that investigation. Okay. That's an option also. Still kind of thinking this through, but I wanted to hear from y'all a little bit. How many of you, raise your hand, please, if you've got pretty active involved resources as far as personnel, a personnel officer, HR officer. Okay. Okay. Not really many of you. Okay. Um, Sharon, can you share with me Darlene's comment there? I didn't catch all of it. I'm sorry.
Sure. The Darlene says the employees may speak to the director or assistant director here with the understanding that they will speak with each other unless the claim is against the other. They just may feel more comfortable with one or the other.
Hmm. Okay.
So I believe she's saying maybe personality wise, some people are more comfortable with the assistant director versus the director
I get
in
it.
in opening up. Is that
Yeah,
what you meant, Darlene?
and I could see also, Darlene, that maybe your assistant director may be more um accessible. Okay, I see. Okay. Yeah, and it may be that the assistant director is more accessible than you as the director. You may be different places for meetings, et cetera, so that may come into play. If the complaint is concerns the director, though, for the complaint to be made then to the assistant director versus the complaint being made to at least the chair of the board of trustees to initiate an investigation about it than about the director. I think we got to have some ability to go higher than the director if the complaint's about the director. And so that wouldn't be appropriate there for the complaint to go to the director or the assistant director. With the Mississippi State Personnel Board for the 25,000 state employees out there, the process is in the state employee handbook. If an employee is being harassed, workplace discriminatory harassment of any type, that complaint can be by their executive director at an agency. They can make the complaint to the Mississippi State Personnel Director, and the state personnel director will conduct an investigation. They're authorized to do that concerning the complaint. So as long as the complainant has options on reporting, okay. I think that's what's important. Um, so again, the instructions on reporting harassment separate from an actual grievance process. Just a little bit more. Almost done here. Okay, almost done. We looked at the accommodation policy. We'll be providing more information to you about that. Okay. Let's talk about now personnel decisions and grievance processes to conclude. Okay. Um, a personnel decision such as salary, promotion, assignments, or scheduling, disciplinary action less than termination. Uh, and looking at a lot of your policies, you have there are very broad statements for issues, again, like we've said, to be, quote, grievable, and that would trigger and allow for an employee to go through the steps of that grievance process. But all these grievance processes ultimately can land, or they land at your board of trustees. Um, as far as, again, the grievable issues, we talked a little while ago about one policy, any feeling of dissatisfaction or injustice in connection with one's employment situation. Very broad. Here's another one. If an employee disagrees with the established rules of conduct, policies, procedures, or practices, then they can go through the grievance process about that issue. Again, it states if an employee disagrees with the established rules of conduct, policies, procedures, or practices, then they can go through the grievance process. But y'all, again, that's landing at your board of trustees over an issue of an employee just disagreeing with policy. Okay. Here's another one. Any allegation that there's been a breach, misinterpretation, or improper application of policy, practices, or procedures is a grievable issue, or an arbitrary or discriminatory application of terms and conditions of employment. So that was stated in one of the policies as a grievable issue. Arbitrary or discriminatory application of terms and conditions of employment. Well, if I'm complaining about a discriminatory terms and conditions of employment, that's a hostile work environment complaint. That's not a grievance. That shouldn't be a grievance situation. That's a hostile work environment complaint that we need to go through that process with instead. Okay. Um, one last one. Any matter of concern or dissatisfaction is a grievable issue, including complaints of discrimination. One policy stated is a grievable issue, and again, if I'm being discriminated against, that's not a grievance. That shouldn't be a grievance issue. That should be an immediate complaint to my director issue. And also, the performance appraisal ratings uh, are grievable. Again, it's a balance. It's a balance, like I said, between as far as the grievance process and the need for one. It's a balance between your board of trustees being responsible for the orderly and efficient management control of the library system. They're not delegating to you all the responsibilities, but they maintain oversight over that system. So we've got that consideration again versus that the statute, it only requires the removal process must go before that board of trustees if it's in that appeal process. So if anything could be aggrieved or appealed to the board, that's not the most efficient system. So I need to ask y'all, and you're currently, and it may just be that you haven't had to deal with this much, so employees haven't pushed the issue of going through a grievance process concerning a written reprimand or disciplinary action less than termination that they receive from a library director. Maybe they haven't filed that grievance to your board of trustees, but how many of you deal with quite often grievances about these type of issues? Written reprimands, salary, promotion, assignments, or scheduling, discipline, less than termination. Be careful on what we say is a grievable issue. It needs to be very limited. These are just Joe's recommendations and what I'll be talking with the commission about. It needs to be very limited what circumstances are truly a quote grievable issue. You got to remember if something is grievable, and think about it, what we looked at a little while ago, I gave you the examples about how broad this is. Any allegation that there's been improper application of policies, any feeling of dissatisfaction or injustice in connection with one's employment situation, that's way too broad. We've got to have very specific statements on what are issues that are grievable, what are the grievable steps, and because that issue ultimately, if it's grievable, that means it can land at your board of trustees for them to look at that situation and make a decision. And they may, if we say it's grievable and the board of trustees has the final call, just like they do with a removal situation, your board of trustees would be given the authority then in policy to reverse your decision there, to reverse your decision concerning if we said that a promotion is grievable. Not receiving a promotion, a salary is grievable. Somebody being issued a formal written reprimand is grievable. Somebody being issued a suspension without pay by you is grievable. That means it gets to the board of trustees ultimately, and they can reverse that decision. So the state personnel board, a number of y'all's policies, they appear to be they're on the grievance issue. They're taken from the old Mississippi State Employee Handbook from many, many years ago, and that was changed. That was changed a number of years ago uh, by the state personnel board. So it's time to update this and to get that information out to y'all. And I appreciate the opportunity to work with the commission and being able to do that.